Need a microphone tonight. This is very, very intimate. I am going to try and find money to be able to advertise this series better, because this is just frustrating since the quality has been so exceptional, and I really think that it's a shame. But anyway, this will be a recorded lecture, and always, if you miss one, you can see on our website that we post the videos of the lectures as they come out. So we get to listen to Joan Kee today, and it's truly a pleasure to see her again. I haven't seen her in quite some time. She's lectured for us before, but I met her many years ago now at the National Gallery when she was a CASVA fellow, and she's gone on to have a really illustrious career in our discipline, and she teaches at Ann Arbor, University of Michigan. On modern and contemporary art. She has a really interesting approach, however, and I thought it was cool the way that she described it. She practices, I hope that's not my phone, what might be called an applied art history, where close visual analysis offers insight into extra artistic phenomena, such as the law, which is her subject today. But I should say that her first book, published back in 2013, which was also award-winning, was very, I think, innovative in that it established the international reputation for a little-known at that point group of abstract artists of the 60s and 70s, known as Tansekwa. Did I say that right? And that pretty much put them on the map, and she's now acknowledged as being the one, who made this movement actually perceptible, and many people now are studying this area, which is just, a wonderful contribution. So she's incredibly original in her scholarship, and, that's why I thought that, in particular, since her new book just came out, Models of Integrity, Art and Law in Post-60s America, that it would be a great opportunity to listen to her talk about her subject. She has promised me, though, that this is the user-friendly version of her book, and I'm sure it will be very interesting. And I suppose, since we are such a small group, you should feel free to interrupt her if you have questions or if there's something pressing that you'd like to ask. Otherwise, we'll have a little bit of Q&A, as always, at the end of the talk. So please join me in clapping as loudly as you can so we make it sound like there are more of us in welcoming Joan to the stage.
Well, thank you very much. And thank you for those of you who've come out today, because being from Michigan, where the day I left, it was 42 degrees and people were wearing shorts in celebration. And so with this weather, that anyone can come to, say, an academic lecture deserves a medal in and of itself. One thing to note is that I am a refugee lawyer, so I actually came to art history after practicing law in the deep bowels of New York and Hong Kong. So in some ways, this book is, oftentimes people like to say that people's dissertations are both, say, therapy and a good way of knowing what kind of person that is. And so when you write about, say, art and law, part of it is kind of trying to unleash, say, certain sorts of traumas that had accumulated when one is doing due diligence for 30 hours straight in a windowless room. So having said all of this, let me begin with this work that originated in 1974. And here we have the Los Angeles artist Suzanne Lacy. And she worked with an attorney to draft a 13-page contract outlining her desire to sell various body parts. It allowed a purchaser the right to buy her organs after her death. Titled Body Contract, it was a striking reclamation of self. Barely a year after the Supreme Court decided that the right to privacy applied to abortion decisions in Roe versus Wade. Oops, it's going fast. Lacy's own references, however, pivoted largely around laws and articles concerning the sale of organs, which attended its own share of heated controversy in the early 1970s. California, where Body Contract was created, saw innumerable advertisements lodged in the back pages of newspapers, placed by those selling organs to pay for health care. By turning to the contract, a kind of documentation exemplified as an expression of free will, Lacy underscored her personal volition at a time when women's bodies were still most recognized as forms of property. And this is a time when women accounted for less than 5% of all practicing lawyers in the United States. Yet the pricing of body parts, and here the heart is valued at $400 and each ovary at $200, cannily resonated with the push towards deregulation, as well as how bodies must conform to regimes of exchange and monetization. Body Contract addressed how countless individuals sold various organs and other body parts for cash. And although it was illegal for living persons to sell non-vital organs, a practice some legal scholars have described as inevitable in light of growing demand, the sale of body parts raised concerns as to whether some individuals might be coerced in sacrificing their health for pecuniary gain. The contract itself was standard boilerplate, save for the terms in the first few pages where Lacy prices each of her body parts. In an indirect allusion to Roe versus Wade, we have also the womb that we don't see here on the chart, but the womb was valued at $1,000. But the contract was more than a metaphor for the monetization of bodies. The production of a legally binding contract made the susceptibility of bodies visible in a way that would be legible to non-art audiences, and especially viewers, such as lawyers. Body Contract carried forward the matter of artistic obligation. How and should artworks raise hypothetical legal issues? Can and should we mine artworks as grounds for legal issues yet to be raised? Certainly, Body Contract underscored the futurity of law by anticipating the uneasy alignment between contracts as a privileged medium of autonomous attention and policies permitting the sale of non-vital organs, yet structurally made it difficult to have the kind of healthcare system that might do away with the need for these sales. Between 1970 and the mid-1990s, when significant legal changes affected the production and circulation of artworks in new ways, artistic negotiations with the law became the grounds for thinking otherwise about the potential of both law and visual art as reciprocal sources of creative social agency. Existing commentary has framed this relationship as a question of what law has done with art, or what law has done to it. The working assumption is that visual art needs to be saved from the oppressive grasp of the law, or at the very least, it's about assigning blame. Today I'm going to speak about specific artworks and how actions undertaken in their production and circulation provoked or ran parallel with various doctrines, rituals, structures, theories, and forms invoked in the name of the law. Far from representing two opposite points on an intention spectrum, both art and law similarly invested in considering visual material that dwell on questions of experience. The law, in turn, would address these paradigmatic crises throughout the 1970s and 80s, with courts and legislatures introducing or significantly revising regulations concerning property, contract, identity, the family. These responses coincided with parallel shifts in the art world that saw the rise of conceptual art, a renewed awareness of artistic practice as a form of labor, and the continuity of visual art and life as seen through the emergence of performance that took everyday life itself as their subjects. Extremely aware of law as a force empowered to shape how we live, artists produced work that engaged directly with these changes. And here we see a detail from a large-scale work done by Suzanne Lacy in 1977 called 3 Weeks in May. And what it was it was made in collaboration with the Los Angeles Police Department, where each day she would receive a report of all the rapes committed in the LA metropolitan area for that day. And wherever those rapes took place, she would then apply a large stamp, such as you see in the below right, where you had a stencil and then a large, and then red, that would then indicate where the rape had taken place. The map itself was then showed in an outdoor public area in LA. So one of the other recurring themes or questions for today is looking at art that is deliberately produced, say, outside the gallery, or how is it that we can think about art's social purpose as drawing from the place or location in which it is installed. So before us is a card mailed by the Museum of Contemporary Art in San Francisco on behalf of the artist Dennis Oppenheim. Against a view of the infamous San Quentin prison in Northern California are 187 shiny hubcaps, all of which the artist stole from parked cars in the area. Designed by the museum's founder, Tom Marioni, few images show more clearly how art escapes the law. Here, criminal evidence literally pools at the foot of the prison. Conceived and executed between 1971 and 1972, Oppenheim's work took root in a context where artists moved out of the galleries. Yet it also heralded the rise in the number of artists turning to crime as both a subject and a medium. Oppenheim confessed an attraction, in his words, to subversive fugitive functions that could count to the real world and all its philosophy. Against a context of Vietnam War-era America, the turn to illegality reflected what for many citizens was the diminished credibility of law, especially as incidents of political and police malfeasance undercut government authority. Despite the bravado of triumphantly photographing hubcaps against the backdrop of one of the most notorious prisons in North America, the striking aspect of the work was the minorness of the crime. It may have been Oppenheim himself who put it best when he pointedly observed how most infractions committed in the name of art were little crimes. Ranging from petty theft to casual acts of vandalism, such violations recall earlier legal history where crimes were divided according to severity. One thinks of how punishments for theft depended on whether it was grand or petite, depending on the value of the stolen item. More recent is the separation of crimes into legal categories like felonies and misdemeanors, where the threshold separating the two, at least for crimes against property in the United States, is a surprisingly low $500. The minorness of crimes in the creation or execution of artworks can also be defined as objects or situations so proximate to ordinary life that they cannot be seen exclusively as art. A paradox of legal history is how more violent, or in legal jargon, serious, crimes committed in the name of artistic production can sometimes fare better in the eyes of a judiciary when defended as forms of art, such as the art defense, being not that dissimilar to the insanity plea. Yet serious crime all too often reinforced the segregation of art from the world many artists hope to change. Conversely, artists who committed lesser crimes were much more likely to engage the world of human relations on a more specific and local scale. For them, the social import of their works had less to do with explicit declarations of protest than with reshuffling various relationships, including between persons and things, so as to put viewers face to face with their own moral assumptions. And unlike major crimes, which tended to polarize audiences, the dilemmas born of the petty violation repel the formation of easy black and white thinking. The feelings tend to be far more mixed. Not all crimes were equal, however. So compare the reception of two works by the LA artist Chris Burden. The first here is from early 1972, and seated on to his right is the art critic Phyllis Luchins, who had invited him to propose a performance for her cable TV show in Irvine, California. Subsequent proposals were, according to Burden, censored by the television station or by Phyllis, so instead he agreed to a live televised interview. Burden brought his own camera crew to also document this event. During the interview, Burden sprang from his chair, held a knife to his interviewer's neck for the next several minutes, and threatened her life if the station stopped live transmission. By all accounts, the event, known as TV Hijack, was not a collaboration, nor was Luchins notified before of what Burden might do, although the artist stressed that he never intended to hurt her, which, if he did, which would legally have made his action a misdemeanor and not a felony assault. Her fear, however, is real, as was the rage of the television station manager, raising the question of whether the work obligates us to evaluate it through the lens of ethics. Yet TV Hijack was insulated from legal scrutiny, possibly because it registered so strongly as spectacle, as a staged performance. Now, here is another work by Chris Burden. It's from 1972, titled Dead Man. And here, in contrast, it was a relatively low-key work of Burden's that actually got him into legal trouble. Dead Man took place at the Mizuno Gallery in LA, and according to Burden, what he did was to lay down on a busy boulevard at 8 p.m. in the evening. He lay down on La Cienega Boulevard at 8 p.m. You can just imagine it's probably not the best idea. And someone covered him completely with canvas, with flares placed nearby to warn oncoming traffic. Just before the flares died, a police car arrived and arrested him for causing a false emergency to be reported. The police saw a different story, one corroborated by the photograph documenting the event. To them, it was a body beneath the rear wheels of a car covered by a heavy tarpaulin. 2 road flares had been struck and were lying nearby, and immediate thoughts of accident and death came to mind. A large crowd had gathered in a semicircle around this accident and into the street. Burden was accordingly tried and acquitted for causing a false public alarm. The differences in reception accorded to TV Hijack and Dead Man show how illegality is relational, with some actions attracting higher scrutiny because they occur in a public space. But the differences also insinuate how the category of art now functions as something of a boundary. If an action seemed beyond the pale of social norms, it is much easier to tolerate if it's classified as art, a category the law defines as both subject to the rules governing property and as fundamentally separate from everyday life. Minor crimes, however, are much more contiguous with daily routines and therefore less likely to benefit from the art defense. The history of these little crimes can be traced to the figure of the trickster, a popular trope that overlaps with the idea of the artist as criminal, particularly the con artist. By 1971, the rise of conceptual art in the US and Western Europe had prompted tongue-in-cheek comparisons, likening the con of conceptual art to the con of con art that we see on the left. On the left is a Malaysian artist, would be sort of the equivalent of the Lawrence Weiner of Southeast Asia. And he stands next to a large placard that had been set outside his studio while he was studying at the University of Hawaii. And the placard was put up by a colleague named Laura Ruby, who was decidedly not a fan of conceptual art. So there you have the con job art and all of its faults enumerated one by one. On the right is an example of one of the many advertisements that was placed by an artistic duo called the United Art Contractors. And what they would do was to buy advertising space in Art Forum. Again, at the time, the journal of record for contemporary art. And they would have ads such as Yoko Ono, be our patron, or artists willing to sell their artwork for pennies on the dollar. Now, one of the interesting kind of side notes is that both of the artists who participated in United Art Contractors eventually decided to enroll in law school. Now, such artists, with this idea of, say, the trickster maps onto legal structures as a nuisance, or defined as the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment of or use of another's individual property. Now, nuisance is also defined as injury, loss, or damage suffered by the local community as a whole, rather than by individual victims. In such cases, the injury has to be substantial and unreasonable. Consider, for instance, the Billboard Liberation Front, a loosely knit San Francisco area underground organization that for 23 years has, in their words, improved billboards in San Francisco by changing advertising messages with a decidedly countercultural sensibility. Many of these billboards have in fact been cited as evidence of nuisance, but to my knowledge, the artists that were responsible for erecting these billboards have never been formally indicted. The other lineage to which the petit criminal, or the petty crime, belongs is the figure of the guerrilla. The word refers to calculated, low-tech actions of incremental pressure, where battle was less about the deployment of brute force than it was about victory through an accumulation of small disruptions. But the guerrilla could be looped into tropes like infection, especially as groups, like the Guerrilla Art Action Group, became interested in how it could affect mainstream institutions from within, rather than impose a new system of governance from outside. In November 1969, the members of the GAAG, the Guerrilla Art Action Group, John Hendricks, Poppy Johnson, Jean Tosh, and Sylviana Goldsmith, entered the lobby of the Museum of Modern Art in New York on a Tuesday afternoon. Wearing business clothes, they suddenly threw to the floor copies of their demands, including calls for the Rockefeller brothers, who owned considerable percentages of multiple companies profiting from the Vietnam War, to resign from the museum's board of directors. Then they violently attacked each other, causing bags of blood hidden under their clothes to burst. A crowd gathered, and the action slowly moved from a tone of violence to that of anguish as the artists writhed on the floor, moaning, before eventually going quiet. The group then rose to their feet to bystander applause and dressed themselves in overcoats that covered the bloody remnants of their clothes. 2 policemen were summoned and later arrived, most likely to detain the artists for interfering with the use of a public space, but by then the artists had already left. The belated arrival of the police is crucial, for it suggests how law is not an absolute system of regulation, but is itself subject to the rule of time. In the case of violations, Oppenheim was likely to have known that even if the most zealous prosecutor were to see the mailer, the likelihood of his apprehension was minimal at best. Not only would it be extremely time-consuming to trace the individual hubcaps back to the cars, the slowness of the judicial system, created by a backlog of cases, would further deter even the most tenacious defender of justice from pursuing a conviction. In one sense, Oppenheim had his fellow perpetrators to thank for his freedom. To leverage the difference between the timetable of the legal system and the timetable of artistic making, this is what Oppenheim meant when he described violations as fracturing the law as opposed to breaking it. The task, he said, lay in identifying areas of unresolved tension within the law, its contradictions, blind spots, and conflicts of interest. The prominent inscription of Oppenheim's name on the mailer, and later a video, which we see on the right, showing him actually prying each hubcap, points to another key imperative: owning up to one's actions. Accountability was necessary to establish the artist as someone whose word was good and perhaps even better than the institutions she or he challenged. In 1969, the Museum of Contemporary Art in Chicago, then one of the most progressively minded museums in the United States, staged art by telephone. Artists phoned instructions to the museum, which would then undertake the production and display of works. For his contribution, the artist Richard Archwager proposed that the museum call a friend of his who would steal an Oriental rug. The purloined rug would be displayed in the museum alongside a label marked Stolen Oriental Rug, with the label having exactly the same format and typeface as other labels used in the museum. For Archwager, the key was the label, for it would hopefully provoke viewers to consider the relationship between the object, the label, the museum, and their own position as audience members. An unspoken subtext was how the label called attention to the lack of transparency that seemed to define museums at that time. One considers that in the late 1960s and early 70s, it was a time when encyclopedic institutions were procuring artworks under ethically questionable circumstances. A good example would be the dubious provenance of the famous Euphroneous crater purchased by the Metropolitan Museum in New York in 1972. Was Archwager trying to model the transparency that museums and even institutions in general fail to demonstrate in their efforts to preserve their positions as temples of cultural propriety? As pointed as Stolen Rug was, missing, however, was a sense of Archwager's own accountability in directing a friend to commit a crime on his behalf for the sake of his art. Personal accountability was a factor in other works such as J. Jaroslav's extended credentials. And here, using his credentials as an MIT-employed scientist, the artist J. Jaroslav accessed and copied birth records of dead infants at Boston City Hall and used these credentials to obtain social security cards, driver's license, and passports, eventually producing 31 legal identities in 5 years. Jaroslav thus created an identity chain that illustrated how birth certificates, perhaps the least secure form of identity, could be used as breeder documents to obtain other forms of documentary citizenship. Titling the resulting work Extended Credentials to reflect its extension of a previous work listing various emotional states and actions as resume credentials, Jaroslav never used the documents except as art, and the only exception being perhaps his unwitting role as an advisor to contemporaries who sought his advice to create false identities in order to avoid the draft in the sunset years of the Vietnam War. Yet extended credentials presaged not only concerns over the use of breeder documents in organized crime and by terrorists in the late 1970s, and in illegal immigration in the 1990s, but also how identity theft, a phrase almost completely unknown before 2000, would pervade everyday life on multiple scales, from legislation to casual conversation. Although he intended to continue breeding identities, Jaroslav also knew he would eventually be apprehended, an awareness he built into his exhibitions by shrink-wrapping birth certificates so as to prove they had never been used except as artistic material. One critic observed that the work actually created a situation that forced the government to prove the artist's intent to defraud, a challenge prosecutors succeeded only partly in meeting when the artist was convicted of mail fraud, a serious federal felony, yet received a much lesser sentence than was typical. In this case, law-breaking helped flesh out that which existing legal structures had yet to properly articulate. Other works provoked encounters with the law that forced them to explain what their works in fact were. And here we look upon evidence gathered for the trials of Japanese artist Akasagawa Genpei. In 1966, he created mock 1,000 yen notes, invitations for a show, which the date would be printed on one side and a mock-up of a 1,000 yen note on the other. Despite the notes being clearly unusable as legal tender, it was nevertheless a highly charged activity given the prevalence of counterfeiting in Japan at this time. The Japanese legal system prosecuted Akasegawa to the fullest extent of the law, rejecting wholesale his defense that the notes constituted a form of art. Part of the tenacity was due to a judicial system that was high stakes, not only for the accused, but also for the prosecution. By the time a case goes up for trial in Japan, the prosecutor is expected to win. Losing often means being reassigned to a less desirable part of the country in a smaller, more obscure court. Akasegawa's lawyers urged him to describe his works as art, which as a legal defense appealed to an unspoken assumption regarding art's relative triviality, exemplified by phrases as, "Oh, it's only just art, it's merely art." That the Tokyo District Court absolutely rejected this defense, however, attests to how the avant-garde may have been on the social fringes, but was nevertheless recognized as a potential social force. Part of the issue with Akasegawa was that he was seen as stealing from the Japanese state, which at that time prided itself on defending individual property rights. But the identification of objects foregrounded how counterfeit is an area where the law is most attuned to questions of materiality, the texture of paper, the color of the ink, the placement of images, the thickness of the sheets. Indeed, counterfeiting in the name of art, whether real or perceived, may be the point at which the encounter between art and state is most visceral. Critiques of property became media spectacle writ large in the hands of German artist Uli, who in 1976 drove to the Neue National Gallery in Berlin and stole Karl Spitzweg's Der arme Poet from 1839, a much beloved painting by Hitler. I'll show you a very brief clip. There is the intrepid artist on his way to the museum. That's his target. Literally takes it right off the wall. I don't know if we can do that here in at the Santa Barbara Museum. No. Now he's making a run for it. Yes. So he's making a run for it, and then what happens is that he takes the painting to the home of a Turkish immigrant family that he befriended. And so this painting that, again, originally is installed at the Neue Gallery is replacing a painting that this family, that is in this family's possession.
Millionen Mark geschätzt wird, ist wenige Stunden später dem Museum zurückgegeben worden.
And so what happens is that Uli actually goes into a telephone booth and phones the museum to say that he has the painting and to also indicate where the painting is located. And so within 30 hours of the theft, the painting was returned unharmed and the incident glossed over as a form of action art. So the work bears strong situationist overtones. And here one recalls Guy Debord, who tells of some revolutionary students who made an armed attack on an exhibition of French art and carried off 5 paintings that they subsequently offered to return in exchange for political prisoners. Now, Guy Debord, the French theorist, links this incident to how, during the Dresden Uprising of 1849, a proposal was advanced to place paintings from the local museum at the city's entrance to halt the advancing troops. This, he said, is clearly an exemplary way to treat the art of the past, to bring it back into play for what really matters in life. But unlike these idealistic speculations, there's also something odd about the implied grandness of gesture. Uli assumes both more and less of his action than what in fact took place. On one level, the action displays the potency of the institution and its admonitions against touching the work, but falls short of its situationist aspirations to complete that displacement. In fact, the liberal myth of the heroic renegade artist emerges stronger than ever. Uli's performance is an allegory of how oppositional artistic identity can be generated through a dialogue with legal culture, with criminal activity at the medium. By placing the work in a home of a Turkish guest worker, Uli tried to mix the social spheres. Yet little was said about the potential jeopardy his actions put the family, whose own legal and social status as a foreign guest worker was far more precarious than Uli's own. The artist did pay the price for his action with both time and money. In his case, he was offered a choice between a 36-day prison term or a 3,600 Deutsche Mark fine, roughly $6,000 in today's currency. But the cost his actions imposed on others was left unnoticed and undiscussed, including of how Uli left his friends to pay the fine after he fled the country. So, can't trust anyone these days. The crimes committed by Jaroslav, Uli, and Akasegawa were all serious, carrying penalties far stiffer than those received by Burden for Dead Man. The nature of their actions were thus far removed from the experience of most audiences, likely to see them as one-offs that seemed more real in theory than in practice. Little crimes, in contrast, had their own power because of how they mirrored what might repeatedly happen in the course of everyday life. Compare Uli with the American artist Anne Messner, stealing cheap cotton shirts from the summer end sale of the C&A department store in Cologne, Germany. Perhaps the most radically unradical artist of her time, Messner had long been interested in what she described as the gray zone of what's permissible in terms of material and how you get it, what you are allowed to work with, and questions of authorship within that. The gray she refers to are the blurred boundaries between permission and entitlement, whose legal parameters were then being debated in ongoing legislative contests over artists' economic and non-economic rights. Like many of her peers, Messner was weaned on the declarations of political radicality of the 1960s. But the actual performance she enacted, called Stealing, was hardly nostalgia for revolution. The work took place in direct view of multiple surveillance cameras, which simultaneously broadcast images in real time on a store monitor in the vicinity. Messner positioned herself near a pile of cheap shirts from which she initially took one surreptitiously, then others more boldly. There she is layering one shirt after another, so she starts to resemble a Michelin man by the end. Now here Messner's acts read very differently from those of Uli, who saw his actions as a form of revolutionary liberation, or at least tried to make his theft appear as such. Messner, on the other hand, is steeped in the prosaic banality that defines shoplifting, which in many U.S. states actually considered below the level of a misdemeanor if the retail cost of the stolen goods is less than a certain figure or if it is a first offense. Bravado and glamour are conspicuously absent, as are the vigilante instincts of Uli, who drew more attention to himself than to those implicated by his behavior. As he recalled somewhat pompously, "The Berlin action brought a stigma with which I learned to live, but it also set criteria for my artistic intentions." Present in Uli's statement is a lingering fascination with himself as the criminal. What he had learned to live with was that it was not enough to marvel at crime, but to face its repercussions. Messner pointedly rejects the script of the heroic thief. Instead of a notorious, one-of-a-kind painting, she takes cheap, mass-produced shirts. No one notices, except for a woman who looks askance here, side-eye in action. And I think Messner herself is taken aback by the indifference. She takes another shirt and puts it on, in a vain attempt to draw attention. The repetition merely confirms that yes, no one is going to say anything even as she is being watched constantly by the prominently installed surveillance cameras. That we see her through these very cameras emphasize how technology has relieved us of the duty of vigilance. The lack of bystander response illustrates how indifference is itself a form of self-regulation, by which the everyday maintains its even keel, especially in public spaces. How getting away with minor crimes often takes place because people don't want to be rude. They don't want to violate the norm of civility. Even the skeptical woman casting a doubtful eye on Messner remains silent. Through stealing, we see how the enforcement of law can depend on the willingness of bystanders to violate civility by accusing a stranger of wrongful activity. Stealing emphasizes how little crimes make legible disruptions otherwise neglected or forgotten in favor of more familiar narratives of resistance and protest. Such works destabilize the binaries of good versus bad, right versus wrong, with which the law is so closely bound. Above all, it highlights the difference between the everyday and the merely ordinary. The former is much thicker and more impenetrable than what the latter might suggest. Minor crimes are perhaps better able to address the impact of daily life than are spectacular events or accidents. Pissed Off is a 1981 performance by David Hammons, where the artist famously urinated on a sculpture by Richard Serra, then a byword for post-minimalist sculpture. Hammonds' performance takes place near the soaring TWU, Richard Serra's work installed in Manhattan's Tribeca neighborhood. The critic Jean Marino talks of Hammonds' gesture as a deliberate misuse, justified by the new meanings it generates. But I'm particularly intrigued by what Marino calls the unprofessional pleasure of Hammonds, that the artist's actions opened the door to speculation about the pleasure inherent in defacement and destruction, while also calling attention to the aspirations of artists wanting to be taken seriously by the law. We know of this work primarily through photographs taken by Dawood Bey, then known for his seminal photographic series Harlem, USA, documenting everyday life in Harlem from 1975 to 1979. Bey's pictures show Hammonds casually urinating in a corner, formed by adjoining slabs of the sculpture, and then most oddly, interacting with a New York City police officer without any overt hostility. Whether or not Hammonds was in fact arrested for his misdemeanor remains unknown. Some questions that the photographs raise include whether it would matter if he was arrested, or whether it was enough to suggest criminality by the presence of the police. On one level, the very presence of the burly white cop throws into stark relief the very real risks taken by Hammonds, an African-American man committing a crime in public. Yet the absence of explanation regarding the interaction with the police leaves open questions as to whether they, and for that matter Hammonds, was likewise keeping open the problem of how Black male bodies are knitted into the social fabric through criminal behavior and subsequent arrest. The photos cast aspersions on the nature of photography as evidence. What do these actually show? Hammonds is breaking a law that belongs to property law, which itself has been criticized as a reason why artists fail to fulfill what Hammonds claims is their responsibility to be mavericks. As he told the art historian Kelly Jones in 1986, property concerns make it so hard to live in the city. The rent is so high, your shelter and eating, those necessities are so difficult to come by. That's what keeps artists from being that maverick. Now, the Sarah sculpture is not the same thing as shelter, but that Hammonds chooses to pee on a Sarah sculpture seems hardly coincidence, given how in 1981 was the year when another Sarah work would become the example of artists struggling to claim special privilege within existing intellectual property law. And here I am thinking of Tilted Arc. Now, Tilted Arc began construction almost simultaneously, was pissed off, and in the summer of 1981, and even before its actual construction, Tilted Arc drew a hailstorm of criticism, indicating how the category of public art was now a function of the collapse of populism and democracy. Opponents of the work claimed that Tilted Arc should be removed because a majority of the people didn't like it, an argument that ran counter to how Sarah himself had been chosen by a set of verified procedures, that is, through the rule of law. Read in this light, Pissed Off appears as a gesture towards undermining the idea that public art should be about the formation of community. For art to be genuinely public means being able to encourage, provoke, or at least accommodate dissent. This is not to gloss over the legal status of Hammonds' actions, but to also think of other associations. What was key was performativity. Hammonds performed to a T the role of the derelict, and in doing so called attention to how Sarah's work performed as something only that could be understood from aerial views or from a distance. And as Hammonds would consequently demonstrate as one of his best-known works, Lizard Ball Sale of 1983, the concept of property reigned eternal. In this work, he sold snowballs in different sizes, ranging from extra small to extra large. By assigning value and appearing to seek profit from a commonplace, short-lived object, Hammonds channels the role of the trickster in order to reflect back upon a world where the creation of value through commodification seemed more central than ever before. Let us look at one more Bay photograph of Pissed Off, this time showing Hammond standing in the center. It is more than record keeping. The snapshot-like image lets us glimpse into the parallel realms of activity Hammonds occupies. Compositionally, it resembles a snapshot taken by a passing tourist. Yet the cropping of the image recasts the planes of Sarah's works, making them appear as if they could be the walls of Hammonds' studio. If we believe Bay's photograph to be part of Pissed Off, it is both evidence of Hammonds' work and how Black productivity is so often paired with images and fantasies of ruin, waste, and destruction. On one level, the deliberate violation of law counters the values art must traditionally convey for the law to consider it legitimate. So instead of beauty, optimism, virtue, and accessibility, we have instead bleakness, deviousness, and the disreputable. If petty crime became part of the contemporary art toolbox, it was also to highlight just how enmeshed art was with everyday life as structured by the law. In particular, the accumulation of these decidedly minor provocations helped purge from daily life the complacency that few could afford to feel. Thank you very much.
Well, yay.
Hey.
Do you want to take?
Sure. I don't even know if this is on, or do I even need a microphone? Okay.
It is on.
It's on? Okay.
Yeah, so you can walk around if you want to. But we're such a small group. Does anybody have any questions they'd like to pose?
Yes.
I was just curious, where were most of these pictures taken?
So these are all taken near Tribeca. So yeah. So the Sarah sculpture was it was the giant TW sculpture that was towards the entrance of the Holland Tunnel. So that little circle, that rotary, that once you get into the Holland Tunnel, usually they put a big public artwork. New York, yeah.
Wow.
I'm disturbed by the ethics of breaking the law and calling it art. And to me, it's off a very thin line between what you can say, oh, isn't that cute or isn't that nice? You would go in and with a knife or a spray can and destroy or try to destroy paintings in museums that we all
Speak
love.
up a little bit.
I'm disturbed about the ethics of breaking the law under the guise of calling it art. I think that's an excuse. Some things are okay, but other things are clearly not. And by treating it seriously as you're dealing with your scholarship, are you at all concerned that you are enabling or enhancing people to break the law in this way?
So a couple of things that your question raises. So one is, so usually when art, or the legal history of art usually tends to think about artworks as property. And so once you start having these provocations, suddenly you start to have lawyers and legal scholars commenting on just as what you talk about. Are these actions ethical? Are they justified? Is art enough to validate these kinds of actions? My interest is not necessarily about validating or celebrating these works so much as they represent a moment in the history of contemporary art when it wasn't just enough to say, oh, compositionally it makes sense, or it has aesthetic value, but that these sorts of ethical questions, is this, say, morally just conduct? That also becomes part of the criteria of how we assess whether or not something is valuable or worth preserving. So for me, the questions that you raise in terms of the ethics is something that something that has a certain kind of, say, historical moment, especially in the 1970s and 80s, when one of the reasons why breaking the law was so commonplace. And I do draw a line between, say, when you break the law that results in direct harm to another person. So for example, the knife held to someone's throat. Or a more recent example might be performance artists who performance artists who involve other people in their works and don't pay them anything. So another form of exploitation. So those sorts of works I think are ethically unjustified. But there are other forms of illegality that took place, especially in the 70s and 80s, when you had New York that was especially derelict, for example. So you had artists who would in fact take it upon themselves to improve or renovate certain parts of the city at a time when New York City just didn't have the money to go about those sorts of activities. And so one of the questions that I also want to think about is, why is it that illegality in various forms becomes so prevalent at this time? And I think in part it's a form of, say, it's a part of assumption of a certain kind of responsibility, at least the kinds of illegal acts that improve property or, say, improve the lot of a certain community. But I don't condone, say, murder committed in the name of art. No, that's definitely not my interest.
So wasn't it during this time where, and I don't know if it was Chris, where one artist shot himself?
Yes. That was him. Yes. Him.
Yeah, that's what I thought. I thought that was insane when my daughter told me about that, and I thought, how can that be art? during that time, and I don't know that I do accept that as art.
So one of the questions that say someone like Chris Burden was again interested in is how is it that he can put his own body on the line? So I think it was one thing to say as an artist, well, we can choreograph a work and outsource the actual performance to other people, but what does it mean to actually put your own life at risk? But one of the other issues was the Chris Burden work, and that was called Shoot, which took place also here in Southern California, was the first work to get lawyers and legal scholars involved in art criticism. So once people started to hear of that work, it became very notorious, is that you had legal scholars talking about, is it ethical to put someone else in that position? Because what that work entailed was that it was the artist who was, the artist was standing at one end of the gallery and he had his friend shoot him in the arm. And so what that did is it's something like the Richard Artschwager work that we saw, where the work could only happen if you got someone else to participate in what was effectively a crime. Now, with Shoot, Chris Burden was never arrested, never tried, in part because the venue where it took place was a private space. It was a private gallery. So whatever happens in your gallery, and that's, or whatever happens, say, in the privacy of your own home, especially, say, I know that in Southern California that privacy laws tend to be stricter than, say, other parts of the country. So one of the reasons why you have a lot of these works taking place, especially around LA, is because the likelihood of apprehension was going to be much less. Now, in terms of the question of whether something is art or not, so for a lot of these artists, it was not necessarily for them, it wasn't necessarily about whether something could be recognized as art, but rather about how do we bring the everyday? How do we, say, muddle the boundaries between art claiming its own sort of separate realm versus, say, the everyday world at large? How do we make art more relevant? And so this is one of the reasons why you had people like David Hammonds, urinating in public, having his friend taking a picture, and the questions of, say, whether or not something is art. So this is part of say, what might be called a larger attempt to provoke an audience into feeling or reacting in ways that were not conventional or were not traditional. How do you get people to pay attention for you, especially when you're moving towards the 1970s and 80s, where it's really about this attention economy or this experience economy? How do you kind of get a share of that? And this is also why art, say in my view, has moved more and more towards entertainment or spectacle, precisely because there's so much pressure to claim what is rapidly becoming an eroding resource, and that is time and awareness and attention.
It takes a very special artist to do that.
So, well, and your comment also implies, say, how is it that certain artists become better known than others? And so one of the other questions that I didn't talk about in this work is that of how is it that one can create a market? So it's not necessarily that works are bought and sold for large sums of money, but how do you create a certain kind of, say, critical mass of interest in a particular artist? And I think with a lot of, say, Burden's works, the works were precisely designed to do that, to again be able to generate interest that took his work and his projects beyond the realm of, say, the gallery or the museum or some of the traditional institutions in which we usually find art. So. Yes.
There's another interesting Southern California one, which was not violent, which was there was a guy who produced a highway sign in Los Angeles. Mm-hmm. There was a sign that needed to be made, and he made an identical sign and got himself dressed up as a highway guy, and he drove out and installed the sign. It's down where you turn on the 5 or someplace, down there, the 2, I guess. And I think they finally left it there because it actually was a useful sign. Yeah. He was caught. I mean, they knew who he was. He videotaped the whole thing himself. And so it's sort of interesting. You have social, it's sort of, you're saying, do something for social value, which was totally illegal, right? I mean, he was making a sign, he was trespassing, he was doing all kinds of stuff. But I don't think anything ever happened to him as far as I recall. Maybe somebody else remembers, but the sign is still there as far as I know, because it was turn left here.
I think it might still be there.
It's probably there. It's one of those green signs.
And that's another interesting point that you're raising too, is that just because something is illegal does it lack value? And so these are also some of the other gray areas that some of these artists are trying to get at. And then the other point that your observation also raises is that in many ways the law is about the management of resources. You just don't have the manpower to go and apprehend some guy who made a fake highway sign because you have to go and catch the 9 million rapists that are loose and wild in the streets of New York. So this is also, for me, the art and law relationship is also interesting because how is it that these sorts of artworks also bring to light, say, certain under-recognized or under-known parts of how law actually operates, that it's not just a big set of rules set in stone, but also a fluid and dynamic operation.
You didn't mention art theft either. It's a whole separate field.
Yes, that is its own.
Which is very
exact,
public,
yeah.
and lots of stuff about, Nazis having stolen art and people are trying to get it back, which is ongoing right now.
It's cultural property is one of the most pressing issues right now. Is say how is it? Should we say return artifacts that we know to be stolen from African countries back to Africa? So that's one of the most well publicized issues.
Especially for museums.
Yes, and it has again lots of say political and racial pressures. So one is that I do some work at the Detroit Institute of Arts, and the chief curator there is a specialist in African art, and he is extremely insistent that these artifacts be returned to Africa. And the counter argument that he often gets is, well, they're nicely stored in the British Museum. Why would you want to repatriate them to countries that are maybe unstable? Maybe the institutions don't have the right kind of climate control. They're not up to standard. And his response is always, well, before they were looted, these artifacts were perfectly in good condition for thousands of years. And if say they were in perfect condition for thousands of years before the advent of say modern technology in museums, I don't see a reason why they shouldn't be repatriated. So these are all the sorts of debates that are just really starting to get some momentum, but it remains to be seen, say, where if the US, for example, will follow France's lead in repatriating, say, cultural artifacts back to their countries of origin. So I highly doubt it, because one of the other issues with art and the law is that depending on where you are and the values that are accorded to certain forms, such as property. In this country, private property is God. It's once you bought it, it is yours. And as opposed to say in France, where the artwork is accorded a certain kind of privilege. So for example, in France, it's considered illegal to step on the face of a painting. And it's a law that one might think is trivial, but it reflects a great deal about, say, the cultural values that, say, the French have in relation to art, as opposed to in the United States until 1976. If you bought a work of art, you could reproduce it however you wanted, you could sell it, you could treat it like a pair of shoes. And that was the phrasing that judges used. Art, it was exactly like a pair of shoes. It does not deserve its own special category. So that's a real kind of way to think about sort of these differences.
I just have a lot of questions actually, but I can save them for when we're just talking alone. But I'm just curious about your book, which I haven't had a chance to look at yet, but I will now because this is so provocative. I'm just interested in how your book is being received. Also, relative to your old profession of the law, I mean, do you think that your book will be used possibly in teaching law to sensitize people to some of these aspiring lawyers, to some of these complexities? Is that part of the implication of what your work is? Because it's really interesting, but it's so untraditional in terms of how normally this material is taught. I mean, I think it's fascinating, actually.
So what was one of the challenges is to be able to both address art history and legal studies audiences. And in fact, there's more interest among legal studies scholars in part because of the way that art and law tends to get written about. It's either about censorship, First Amendment, freedom of expression, about kiddie porn, or it is about, say, cultural heritage issues. But one of the increasing difficulties that judges face is how do you deal with visual evidence? Because you're not trained in it in law school. In law school, you're trained in close readings of text. What does this word mean as opposed to this word? How is it that you would argue a certain opinion? But you now have judges that have to deal with, say, emojis, for example, or have to deal with photographs, have to deal with, say, artists claiming that, oh, so-and-so copied my work. And you have judges that are not schooled in visual analysis. So in many ways, the interest in, say, this art and law project also comes from this real sort of increasing pressure for judges and legal scholars to deal with visual material.
That's really interesting. It's very interesting. I also wonder, though, from the point of view of the discipline, the field, I guess has there been any immediate critical response to your book yet, or will there be reviews that you know that are coming out?
Yeah, so there are reviews that are coming up, but thinking about, say, time and duration, so the slowness of law is only matched by the slowness of academia. So so oftentimes when you have a book the book came out about 3 weeks ago, but to have a book come out, usually you have, say, reviews coming 3 or 4 years later. It's just the slowness of it.
Well, it'd be really interesting to see.
Do you have a little thing that lists the name of the book so that we can find it?
Yeah.
We do have, I think it might be online when you look for the advertisement online for her talk. I think doesn't it mention it? I think it does. If not, we'll make sure it does. But
Can you give me your name again?
My name is Joan Kee, K-E-E, 7 letters. So one of the other, so I wanted,
and that's your last name?
K-E-E. It's three letters.
Joan, K-E-E.
Yes, that's
Thank you.
it. It's really one of the few joys of having a very short name. That and filling out standardized test bubbles. I wanted to do an entire talk actually about California because it's in some ways one of the interesting things about the Art and Law Project is that it really shifts the center of discussion from New York. So contemporary art often centers around New York or Paris. But in fact, it's actually California where the most provocative cases come from. One is, a good example might be Christo and Jean-Claude. So you come to Christo is a Bulgarian immigrant. He comes to the United States in 1972, and he wants to basically erect a giant temporary fence all across Sonoma and Marin counties. And those of you who've been to Sonoma and Marin know that people are very, very protective of how their land should be used or how their land should be occupied. And so one of the issues with this work was not only getting, say, permission from city or state governments, but getting permission from individual landowners, again, dairy farmers mostly. And that involved intense negotiation because if you have it, say, a dairy farm, you're thinking about a dairy farmer and a Bulgarian immigrant who can't really speak English, and he's basically trying to say, I want to erect this fence on your property. That's going to take quite a lot of negotiation and discussion to even get this project started. And so one of the reasons why, for me, this work was something of a talisman was you have artists making increasingly larger and more logistically complicated works, especially in the late 60s and the 1970s. And that entails lots of, say, dealing with lawyers, finding out which regulations that you have to adhere to. The early 70s, this is when California is effectively pioneers the concept of environmental law. So Nixon signs into federal law the National Environmental Protection Act, meaning that if you want to do anything that's a land-based artwork, so which in art history is celebrated as, oh, land art, the lightning field, the spiral jetty, isn't that all very, say, beautiful, is that it doesn't tell the full story of how is it that one needs to deal with, again, these laws that are put into place to safeguard the interests of people who live in a particular area. So one of the difficulties with this work was having to actually produce a full-blown environmental impact report This is a kind of report that's hundreds of pages. It talks about the effects on wildlife, how far you're going to dig into the earth. It's usually only required for major real estate development, not for a temporary fence, which effectively was multiple curtains strung together. So in many ways, running fence was less about, say, the largeness of installation and more about the complexity of having to negotiate with a legal system that was expanding in complex and multiple ways at this time, especially in California.
Yeah, I was thinking about that.
Well, I think we probably should wrap up, but thank you so much for coming.
Thank you. Thank you.